For my presentation, I'll be talking about the case of Anthony Elonis. Elonis began posting violent messages after his wife of 7 years left him in 2010. The messages he posted to Facebook prompted Ellis's now ex-wife to get a state protection order against him and led his bosses to fire him from his job at an amusement park. Elonis was charged with threatening his wife, a kindergarten class, and law enforcement officers, including a female agent who visited his house to question him. All of the threats came through rap lyrics he posted to his Facebook profile. At his trial, Elonis asked the court to dismiss the charges, stating that his Facebook comments were not true threats, but rather he was an aspiring rap artist and his comments were merely a form of artistic expression. He claimed that he didn't mean what he said in a literal sense. In 2010, a jury convicted Elonis on the threatening counts, and Elonis was sentenced to prison. The jury in this case was asked to consider whether the plaintiff had proved that a reasonable person would view the messages as a threat. However, Elonis appealed his conviction to the Supreme Court. In the Supreme Court case, the court also considered Elonis' state of mind. In other words, whether he had intended to issue a true threat. The Supreme Court has said that true threats are not protected by the First Amendment, but they have offered no guidance as to what qualifies as a true threat. The state argued that proving intent should not be necessary, rather people should be held accountable for the ordinary and natural meaning of the words they say in context. Mr. Elonis' lawyers argued that more was required. They said that prosecutors should have to prove that the speaker's purpose was to threaten someone, or that the speaker knew that it was virtually certain that someone would feel threatened. The final verdict of the court was grounded in the principles concerning intent rather than First Amendment protection of free speech, which led to many unanswered questions about the limits of threatening language. We all know that the First Amendment states that Congress shall make no law abridging the freedom of speech. However, it is a federal crime to, quote, transmit in interstate or foreign commerce any communication containing any threat to injure the person of another. So, should a conviction under the federal anti-threat statute require proof that the accused meant what they said in a literal sense? Ethically, I think it should not. For example, let's look at the issue through the common good approach, which says that the interlocking relationships of society are the basis of ethical reasoning, and that respect and compassion for all others, especially the vulnerable, are requirements of such reasoning. In this scenario, Elonis' ex-wife is clearly a vulnerable individual who is not being cared for or respected. Critics might argue that Elonis himself was also vulnerable since he claimed that he was using his lyrics as a therapeutic writing exercise. However, I think there is an important ethical difference between writing privately as a release for your anger and posting that writing publicly where there is a good chance that the target of the writing will see it. The timing and circumstances of Elonis' writing make it impossible to deny that they were intended to scare somebody. There is nothing in the First Amendment that makes speech absolutely protected in terms of its social cost. I believe that under the common good approach, you lose your right to free speech when that speech causes a psychological or physical harm to a person. Critics may say that arguing in favor of the prosecution means that all threats would automatically be a true threat if the recipient of the threat believes it is. The actual intent or dangerousness of the defendant would be unimportant. However, laws don't have to be so black and white. There can be caveats. For example, the judge in the lower court said it was enough that, quote, reasonable person would view Ellison's statements as a serious expression of an intention to inflict bodily harm or take the life of an individual. However, the judge also clarified that careless talk, exaggeration, something said in a joking manner, or in an outburst of transitory anger should not be taken as a credible threat. Thus, I think Elonis' actions qualify as unethical under the common good approach, and I would even argue that they should be illegal as long as the legal decision makes certain caveats.